In just a few short years, litigation funding and the big class action court cases they bankroll has become very big business. With thousands of investors and customers pursuing everyone from the banks to the big telcos, it's seen as a way of bringing the corporate world to account. Now, overseas money is pouring in to finance many legal battles, lured by the prospect of a large chunk of any settlement. But the rush to cash in has sparked concerns from many, including Australia's biggest litigation funding company, that the area needs fresh regulation. Here's Sue Lannon.
From bushfires to bank fees, it seems everyone is joining a class action. Some say Australia risks a US-style culture of litigation.
All of these claims are very, very substantial, and you don't need a lot to have a big impact on the court system and on the interests of investors and targets.
The number of cases has remained steady, but the number of people joining class actions has exploded. Evidence that more and more people are resorting to the courts when they feel they've been wronged.
The increasing prominence of class actions is making corporate Australia worried. The National Australia Bank is facing a case from investors who allege they lost money because of subprime-related investments. The bank's also facing a possible claim against bank fees.
More than 200,000 account holders have signed up so far for a bank fees class action against the ANZ. 12,000 people have registered for a possible case against security breaches at Vodafone. And former corporate high flyers like shopping centre owner Centro and ABC Learning founder Eddie Groves are also on notice for allegedly misleading investors.
I think historically shareholders, note holders, unit holders, etc., when they have lost money, they had to sit there quietly. Now that there are law firms saying, OK, there has been a wrong perpetrated on the shareholder, we can support that.
John Emmerich advises companies on defending class actions. He thinks litigation funders are driving many cases.
Litigation funders on average will take between 25 to 45% of the sum obtained in the case. That might be by a settlement, it might be by judgment, but that's a very significant sum and a very significant commercial driver to fund these sorts of actions.
John Walker is from litigation funder IMF Australia, which finances class actions. IMF has about 10 lawsuits on the go, but Mr Walker says cases only run on their merit.
Every case that we have commenced in security fraud cases have settled for a very large proportion of the claim value. We have had a reasonably good track record in choosing which cases ought to proceed.
Litigation funders are not regulated, and the Chief Justice of the Federal Court has weighed in on the debate. John Walker agrees controls are needed as more players, including overseas firms, enter the fray.
It ought to be regulated, and principally for consumer protection reasons. It's a financial service at the end of the day.
Now that there is money available to take on the case on a united basis, there does appear to be more strength in numbers.
And those numbers are being used to fight corporate excess.